Welcome back. I hope you enjoyed your break. Now moving on to Gonzales versus Oregon, 2006. In 1994, Oregon voters approved the Death with Dignity Act, and it survived in a ballot initiative to repeal it in 1997. What this law said, written in Oregon Green, is that it allows physicians to administer a lethal dose of drugs upon the request of a terminally ill patient in compliance with specific safeguards. Now at the time, John Ashcroft was a senator from Missouri, a Republican of course, and he did not like this one bit. He was not alone in this. And he wrote to the Clinton administration, Attorney General Janet Reno at the time, asking them to act and intercede. Janet Reno wrote a letter in 1998 to Congress saying that she had no authority to act because there was no evidence Congress, quote, intended to replace the states as primary regulators of the medical profession. Ashcroft co-sponsored a bill to do just that, but it didn't go anywhere. Then in 2000, John Ashcroft lost his Senate seat to a dead man, Mel Carnahan. So he became Attorney General under George Bush instead, naturally. At that time, the Oregon Attorney General wrote to John Ashcroft, realizing that there might be a problem here. But one of Ashcroft's aides wrote back to say that he had no intention, and there was no law in Congress coming out that would intercede with Oregon's state law. However, on November 9th, without consulting Oregon or apparently anyone else outside his department, as the Supreme Court decided, Ashcroft issued an interpretive rule in accordance with the 1970 Controlled Substances Act. Now this is the act that regulates narcotics, methadone. It's why we have to write double prescriptions for certain things. And that law was written explicitly to prevent recreational drug use and to prevent physicians from profiting from selling narcotics, basically. Ashcroft said, assisting suicide is not a, quote, legitimate medical purpose, as was outlined in the Controlled Substances Act. Therefore, MDs who did such a thing would risk their federal license to prescribe controlled substances. And you can imagine if you couldn't prescribe Vicodin, it would be rather hard to be a doctor. Therefore, the state of Oregon, a doctor, a pharmacist, and several terminally ill patients decided to sue John Ashcroft to overturn this regulation, to prevent the executive from interfering with Oregon's legislative law. In 2005, John Ashcroft resigned, and meanwhile the case has been churning through appeals courts, and it finally reached the Supreme Court in late 2005 when Alberto Gonzales was the Attorney General. The case was finally decided in January of 2006, and it was a 6-3 victory for the state of Oregon. The ruling laid off addressing the moral aspect, or the broader legal issue of assisted suicide. All it says, rather narrowly, is that the Controlled Substances Act, once again the one that regulates narcotics basically, is concerned with recreational use, and that Ashcroft has no authority to punish doctors in compliance with Oregon law. Basically, the court said that federal standards are okay, and medical regulation is, as it has been traditionally, up to the states. The only federal standard in question regarded recreational use. Whether assisting suicide is legitimate medical practice is therefore not even considered in the Supreme Court's deliberations, probably rather prudent on their case. That leaves the decision up to Oregon and not up to the Attorney General. And it also, as before we discussed with the Washington case, leaves the issue of assisted suicide up to the states to decide as they wish. It also leaves it up to Congress to regulate as they wish, which, as we know, has not been decided by the United States Congress yet. As an interesting, I think, aside note, the majority opinion in the Gonzales case, written by Justice Kennedy, noted that in the United States versus the Oakland Cannabis Buyers Cooperative in 2001, Congress expressed determination that marijuana had no accepted medical use, foreclosed any argument about statutory coverage of drugs available by a doctor's prescription. On the other hand, Justice Clarence Thomas, in his dissent, called it perplexing to say the least, that the court had struck down this challenge to a Controlled Substances Act regarding medical marijuana in California the same year in the case of Gonzales versus Reich. Thus, we have this curious situation where certain members of the Supreme Court think that the federal government is perfectly within their rights to use the Controlled Substances Act to prevent the use of medical marijuana, and another part of the court which thinks that their federal government has no right to intercede in states' medical marijuana policies. This has nothing to do with assisted suicide, but it raises the same sort of issues that we're talking about with the difference between state and federal regulation with assisted suicide. So I thought it was kind of interesting since we live in California. Are there any questions? All right. Well, I want to say thank you very much. It's been a pleasure being on Family Medicine with you all. I want to thank my colleague Nate Mile, who's been a wonderful partner and a great friend. And I want to wish you all a happy Thanksgiving, Happy New Year, Happy Holidays, Happy Hanukkah, whatever. And I will see you back in January. Thank you.